This is Michael Popok, Legal AF. Most news reporting said that Donald Trump somehow won an appeal involving his New York Attorney General fraud case of the century last week. They were wrong. Donald Trump didn't win a thing. He only won that which the New York Attorney General gladly gave him, which was to not immediately dissolve his companies because she needs those companies around and operating to generate hundreds of millions of dollars so she could take it off Donald Trump by way of a fine at the end of the case. That's 3 or 4 months away. What she won and he lost last week at the New York First Department Appellate Division is a motion to stay the trial. Donald Trump sat around for 2.5 days of the first week of trial, didn't like what he saw, didn't like his ex-employees and current employees testifying against him, his longtime accountant testifying against him. And so he wanted to put a stop to it. We're only in trial day 5 of a trial that'll likely last 100 days. On this week's episode, weekend edition of Legal AF, at the intersection of law, politics, and justice, Ben Meiselas and me, my co-anchor, we had a deep discussion about what did the first week look like, but more importantly, what happened at that appeal and why did so many reports get it wrong? That this was a major victory for the Attorney General, not a loss, and a major loss for Donald Trump. Tune in on our discussion right here.
That kind of brings me to this final point on this topic, at least, which is, Eric Trump announced that it was a big victory because the Appellate Department First Division, which is like one of the appeals levels court, granted Trump's and the Trump organization and Eric's motion to stay or just press pause for now on the dissolution of the Trump organization, the cancellation of the LLCs. And here's the thing about that. The main thing that Trump wanted was to stay the trial. That got rejected, as Popok said earlier in this episode. With respect to the dissolution and staying that, New York Attorney General Letitia James was not even fighting that. No one was arguing really even that the dissolution should have to occur immediately before the Court of Appeals makes its ruling. So it's not a ruling on the merits. It's actually, and if you've been following us here on Legal AF and the Hot Takes, we said that's what we thought was going to happen, and that's what we said we thought should happen. The fact that I think Donald Trump is a massive fraud doesn't cloud my sober analysis that you can't dissolve the business while an appeal is pending. Because ultimately, if the Court of Appeals overrules or overturns what a trial court judge, which I don't think is going to happen here, but if that did happen, you can't unring the bell if a dissolution had already taken place. So naturally, if you're appealing a dissolution order and a dissolution takes place before an appeal can be heard, that would be unfair to any litigant. That's why, as long as you just request the motion to stay, any court is going to grant that pending the appellate process. We said that's what's going to happen. That's what happened.
Yeah, let me give a comment
continuing. On that. It's the furthest thing from a victory. It's just the standard procedure. And then the Trumps go out, look, the Court of Appeals agreed with us. They love us now. And it's like, that's not what they're saying.
So here's what happened. I mean, we just from my perspective, because I practice in front of the First Department, I'm a member of the First Department of the Appellate Division of New York. They finally got around, as you said, the Trumpers, to filing their motion for stay, which should have happened
September 26th, the day of.
10 days ago. You and I, if we were handling the Trump case, which we would never in a million years do that, but if we did, you and I would have typed up a motion, a stay, and an appeal waiting. We knew Engoron was going to rule against us, so we'd have like 30 pages ready to go. As soon as we saw the order, we spent an hour to conform our papers to what was in there because we knew what was going to be in there, and we would file it within a minute. And asked for the stay. They didn't do that. A week went by. You and I are scratching our head like, what are they doing? If they wanted to stay, you don't wait until like the second week of the trial to go ask for it. So they got another order. You did it on the Hot Take. We did it on the midweek of Legal AF from Judge Engoron, who then thought better about, well, wait a minute. I don't want them moving assets and changing corporations and to try to beat out my future judgment or the judgment that I've just given. So I'm going to issue a supplemental order that requires the Trump organization and Trump and all the Trumpers to reveal their corporations that they're thinking about incorporating and the ones that they have and any assets that they're planning on moving, and report that over to the Barbara Jones, the monitor who's been in place for almost a year on the original injunction that the judge entered related to persistent fraud way back when. And so they didn't like that order, including that, in fact, that it addressed entities that they said were not in front of the judge. And so they went, aha, now we're going to file our motion for stay. And so they filed papers with the First Department. What happens there is one justice, in this case, Moulton, one justice looks at the papers and makes a decision, but wanted a hearing first. So while the courtroom trial was moving forward with the bombshell testimony that you and I just described, the lawyers other lawyers, including Letitia James, had to hightail it over to Madison Avenue and the First Department to go argue in front of Judge Moulton in person. And when we knew, and there's going to be a video, I'm going to look for it, of the on YouTube actually, for the First Department for the oral argument. But that argument has to be where Letitia James conceded that she is okay with that the entities are not dissolved and their certificates are not dissolved at the present time. One reason, as you said, Ben, is that seems consistent with somebody on the other side trying to appeal. The other reason is she wants them to be an uninterrupted going concern that generates money, because she's going for $500 million at the end of the case. So fine, you want to keep your companies up and running. You don't want to throw people out on the street on payroll. Fine, keep making money. Every dollar you make is going to be mine one day. So I know that's why she did it. I am sure, because she said it outside the courtroom. So I'm sure she said it in her oral argument to the judge. We're fine, Your Honor, with not having the dissolution happen, but the stay of the case. No way. You already the court already denied this 8 days ago. We're 4 witnesses into the trial. No, and the judge, this one judge, for now, said, I agree with you. No stay. Trial goes forward. And on the dissolution, since there's really no objection, I'm fine with putting a pin in the dissolution of the entities only for now, but then reinforce that every other part of Judge Engoron's order, including the requirement that Donald Trump turn over information about what his plans are to transfer assets to other companies, stays in place. Now, he's not the final appellate judge. There's a merits panel of 5, I think he'll be one of the 5, that will get assigned to the appeal on a slow track. That appeal on the summary judgment that was issued on last Tuesday, a week ago Tuesday, about whether Judge Engoron was right or wrong on summary judgment, that's on its own track. That may get decided before this trial is over. It's likely not to get decided before this trial is over. The trial on the other 6 counts and all the remedies that she's seeking, the New York Attorney General, including the big fat fine of disgorgement for $500 million or more plus interest, likely, that continues. So to answer the question, what does the appeal do? Nothing, because they asked for the stay of the trial and they didn't get it, and they're not going to get it from the big 5-person panel either. The 5-person panel will take a look at the papers. They'll get around whenever they feel like it to setting a briefing schedule. There'll be briefs, and 6 or 8 months later, there'll be an oral argument. Meantime, this trial will be over, and they'll have to, if they don't like the results there, they can appeal that. Look, in New York, unlike in other jurisdictions where I practice, you can appeal anything. You don't like an order in the case on discovery, on a deposition, on a sanction that you got hit with in the case. You can take it up on appeal during the case. They don't care. Unlike in other states, like in Florida where I practice, they could never bring an appeal on the summary judgment of one count. They'd have to wait till the end of the case to see, when all the dust is settled, if there's any reversible error. But New York, you drop a pen, you can appeal, and that's what you're watching. But so it did piss me off, and this is going to be part of a subtext of our presentation today, how pissed off I am when I read media reports Sometimes we get hit with, well, you're just repeating what the media. We're not repeating what the media is reporting. We are our own lawyers and our own analysts of our own legal documents. And that's what you're hearing on this show, not something I read somewhere. So, we get the actual legal documents and pull them from the dockets, and we digest them and analyze them with our experience. That's what you're watching. So it pissed me off when some of the reporting was Trump wins. Trump didn't win anything. You can't win that which the other person is willing to give you, which is the dissolution issue. And I think it's for the reason I said, Ben. She doesn't want to dissolve the companies right now. She wants to get the money banked so she can take it from them like taking candy from a baby at the end of the trial.
There's already an independent monitor in place. There's already a very strong order that would prevent Trump from transferring assets, as you mentioned. And so it's going through its normal course. It's going through the process that all of these cases would take. And as I've always said, you get the lawyers that you deserve. And Donald Trump certainly deserves these lawyers, because there was a possibility too late now, after the summary judgment order issued by Judge Engoron on September 26th, if you're competent counsel, if you're competent lawyers, you file a motion to stay that night on the 26th, I could see a world where the Court of Appeals, the Appellate Division, First Department here, would stay this trial and say, let's deal with the dissolution now on an expedited basis. Let's hold the trial. They blew it. They're now in trial for the next 85 to 90 days. We'll see if Donald Trump shows up even ever again. Trump's supposed to be a witness. I don't think he's going to show up. I think he's going to be too cowardly and say, oh, I'm going to invoke my fifth. This is a clown show. Whatever he's going to say, he's going to whine, because he knows that 3 days on the stand getting cross-examined, I've studied his pathology now. I know he's too big of a coward, but ultimately.
But can I make one comment on that, Ben? Because I want to manage expectations. That just because he's not going to testify in the fraud case, and I agree with you, he's not. He has already testified in the fraud case. He decided to waive his Fifth Amendment privilege, having asserted it 400 times in a first deposition. He waived it and sat because he thought he was smarter than Letitia James, which he's not, and was going to talk his way out of this. And all she got instead was a 6-hour deposition transcript and video that she's both played in the opening of the case and will use. If he doesn't take the stand, this isn't a criminal case. If he doesn't, quote unquote, take the stand, his videos will continue to be used and put into evidence because they are sworn testimony as if he was in the courtroom. So there's no hearsay problem when you're playing the defendant's own sworn statements. So that deposition that he, for whatever reason, he decided to give instead of standing on his Fifth Amendment, and you and I speculated he was a little bit worried that under the assumption that a judge makes or a jury makes and is instructed that when somebody takes the Fifth Amendment in a civil case, you are to make an adverse inference that whatever was being asked is true, and they're just taking the Fifth in order to avoid it. That's the big difference in Fifth Amendment application in a civil case, which is what this is, even though it often sounds like we're talking about a criminal case. And so he didn't want that, so he wanted to go and give it his testimony. We will see Donald Trump's testimony, even if he doesn't come into the courtroom to give it.
But if he's under subpoena by the New York Attorney General, unlike in E. Jean Carroll, where Roberta Kaplan, the plaintiff's lawyer, decided that she's fine not having him show up. That was a choice that was made. But if New York Attorney General Letitia James wants him to appear, he's under subpoena. He has to appear. He either would have to invoke his fifth as a reason not to testify, in which case she'll show the deposition, or he'll be held in contempt. But he can't just say, I don't want to be there. It's inconvenient.
I don't think he can take the Fifth. He's already waived the Fifth by testifying, and I don't think he's going to be able to show the basis and that he didn't waive already by giving his deposition testimony. So if she does decide that, talk about ballsy. I would love to see that. I don't know. I don't think she needs him. By the time she gets to her 58th day of trial, I mean, you and I are excited, and we're going to stay excited about analyzing this trial as it goes along. But by day 58, when she makes the decision, I now call Donald J. Trump, she may not need him, but she may want to do it just to roast him.
I think she's going to want to do it sooner than day 58. I think she's going to do Weisselberg. I think she's going to do Eric. I think she's going to do Don Jr., and I think then she's going to want to call him.
I think that's why people come to the MeidasTouch Network and to Legal AF, because we don't blow smoke or sunshine. We just give you the facts, but we give it to you from our unique perspective. I've been a practicing lawyer in New York and trial lawyer for 32 years. I've argued cases at the First Department Appellate Division, just like the ones I just talked about. And I can give you my insider knowledge and analysis, as can Ben with his background as a civil rights attorney. So you've come to the right place if you're looking for facts, analysis, no smoke or sunshine. We will bring and shine that light on these kind of cases every week. We do it on Wednesdays and Saturdays on the MeidasTouch Network on Legal AF. You just saw a clip. If you like the clip, come watch the whole show. And then we put it on audio podcast platforms wherever you can get it. Until my next hot take, until my next Legal AF, it's Michael Popok reporting.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.